They stole my land, built 120 homes on it, and laughed when I pushed back. But what they didn't know is that every inch of it was part of a legal trap I spent years setting. I didn't just take the homes, I took everything. What happened? Next shocked everyone. It started like any other quiet Sunday sun, just rising. Coffee brewing, the sound of birds, and then crack dash boom dash grrrrrrrrnn. I stepped outside in my slippers to get the paper and nearly dropped it when I saw them bulldozers ripping through soil, crews hauling in lumber, and concrete trucks rumbling down what used to be my grandfather's pasture. I froze. It wasn't. Just close to my land it was my land, not a few feet off, not a corner. The entire foundation they were pouring sat smack in the middle of the 14 acres. My grandfather bought in 1957. Land he worked with his bare hands. Land he passed down to my father, and then to me. Fenced, surveyed, paid off, taxes current. I raised my kids out here fishing under the sycamores and watching deer cross the fence line at dusk. This land wasn't just dirt. It was family. It was legacy. It was mine. I jogged toward the nearest worker, waving my arms, confused more than angry at first, thinking this had to be a miscommunication. But the guy just pointed me toward the site supervisor, some 20-something in a hard hat, who barely looked up from his clipboard before saying, "Sir, this land belongs to the Fairgrove Lakes HOA now. You'll have to take it up with them." The way he said now made my stomach turn. Told him flat out, no, that land has never been part of any HOA. I'm not even inside their jurisdiction. He shrugged like it was none of his problem and walked off. That's when the fury hit me. I mean real fury, not the kind you yell with, but the cold, silent kind that settles deep in your gut when something sacred gets violated. I drove straight to the HOA office, sterile brick building with manicured shrubs and a smug-looking receptionist who asked if I had an appointment. I told her they were building 120 townhomes on my goddamn property. She blinked, didn't flinch, and paged. Cheryl. Cheryl was the HOA president, and if you've ever dealt with an HOA Karen, you already know. Her tight ponytail, pastel sweater, condescending smile that never quite reaches the eyes. She walked into the room like she owned a tan to everyone. "In it, Mr. Cooper. I understand you're upset," she said, not even offering a chair. "But your parcel was never registered properly in the 2004 GIS update. Based on our assessment, the land was deemed non-functional and abandoned." My jaw dropped. Abandoned. I was literally paying taxes on it last week. Original deed yellowed with age, but crystal clear. I showed her my 2023 tax bill. I handed over a survey from just 6 months ago. She looked at it all, smiled wider, and said, "Unfortunately, you'll have to take it up in court. But I will warn you, AAR, attorneys are extremely good. And frankly, the project is too far along to reverse. It wouldn't be wise to interfere, Mr. Cooper." That's when I realized this wasn't a mistake. This was theft calculated, professional, and arrogant. Leaned in slightly and said, "You people always think you own more than you do." That line, "you people," it wasn't just dismissive. It was a slap. I stood, slowly, controlled, and told her, "You just built 120 homes on a trap. You don't even see it yet, but you will. Because here's the part Cheryl didn't know. I wasn't just some old man with a deed. I'm a retired real estate attorney, 30 years specializing in land disputes and title defense. And before I ever walked into her office, I'd already re-verified everything. Title search, land patents, archived parcel maps. I even filed an ownership affidavit with the county clerk. My property rights were airtight, and her project was built entirely on land she had zero legal claim to. But I didn't yell. I didn't threaten. I just smiled. Hired a professional surveyor to restake all my corners publicly. Then I filed a cease and desist. She ignored it. Lawyer mocked it. So I filed a lawsuit naming the HOA, the construction company, the developer, and the individual board members. The case was airtight. I asked for full demolition damages and title injunction. Her lawyer called it a scare tactic. Then the judge saw the documents. He halted all development within 72 hours. Cheryl went silent. Investors started calling. Home buyers pulled out. By week's end, the HOA held An emergency meeting, and I showed up with cameras. They begged for a settlement. I demanded ownership of every structure already built. I demanded $2.4 million in damages. And I demanded Cheryl issue a written, notarized apology to be published in 3 local papers. They caved. They had no legal footing, no permits for my land, and no way to unwind what they'd done without my consent. Cheryl resigned in disgrace. The board was sued by its own residents, and I took ownership of the development they thought they'd stolen from me. But here's where it gets good. I didn't sell the homes. I turned them into housing for veterans and retired law enforcement men who've spent their lives defending the very rights the HOA tried to trample. Rent-free first year. Priority for the wounded. I renamed the subdivision Cooper's Honor, and right under the old HOA sign, I placed a new plaque that reads, Private Property. Not an HOA ever, but here's the kicker, the twist I didn't see coming. Last week, I got a certified letter from a major developer who just acquired the parcel next to mine. They're planning an expansion, and according to new zoning maps, they may have accidentally poured part of their road through my wooded corner lot. Different company, different name. But the same mistake. Only this time, I'm not going to warn them, because some traps only spring when you're dumb enough to think the rules don't apply to you. I walked into the Fairgrove Lakes HOA office expecting some kind of reasonable adult conversation. What I got instead was a thinly veiled ambush. The woman in charge, Cheryl, greeted me with that brand of artificial sweetness that instantly makes your skin crawl, buttoned-up pastel polo, perfectly sprayed hair, clipboard in hand, and the kind of smile that's practiced in the mirror and backed by legal threats. She didn't offer me a seat. She didn't ask for my name. She just stood there with her chin high, like she'd already decided who I was and how little I mattered. Mr. Cooper, she said, I understand you're upset. That tone. Like I was some confused old man who wandered in from the cold. I laid the original deed on the counter, real parchment, signed in 1957, with my grandfather's signature still visible in ink. I laid down the tax receipts every year, like clockwork. Straight through to 2023, I unfolded the current survey, notarized and sealed, showing my property boundaries. Every fence post, every legal line, and still she smiled wider. Well, she said, flipping through a few pages on her tablet, technically your parcel was left out of the 2004 GIS update.
Oh.
Our records didn't mark it as private or active, so we interpreted it as abandoned. Developers received approval from the county board last year. Construction proceeded accordingly. I asked her if she'd contacted the actual landowner. She said no. I asked if they'd done a full title search. She said that was the developer's job. I asked why my taxes were still being processed if the land had been declared abandoned. She blinked. No answer. I pointed out that a fence, a real physical fence, had surrounded my acreage for decades. Her reply? Things get overlooked. And then she dropped the real bomb, cool as ice. Unfortunately, if you disagree, you'll have to file a legal claim. But I wouldn't recommend that path. We have a strong legal team. This project has already cost us millions. And frankly, sir, it's too far along to reverse. Sometimes it's better to just move on. Move on? I felt my hands curl into fists at my side. Not because I was going to do something, but because I wasn't. Because I couldn't afford to blow it. That's how these people win. They want you to lose your temper so they can paint you as the unreasonable one. So I took a deep breath and stared at her, hard. I told her calmly that the land wasn't abandoned, that it had never changed hands, that the county may have updated a map, but they sure as hell hadn't erased my title. And Cheryl, God help her, she leaned in and said something I'll never forget. You people always think you own more than you do. That's when the conversation stopped being business. That's when it got personal. You people, it wasn't just smug, it was dismissive. It's disrespectful, dehumanizing. Like I was some confused peasant standing in the way of her suburban empire. Like a man with a deed, a name and a legacy meant less than her shiny development plans. I stood up, looked her dead in the eye, and I told her, you just built 120 homes on a legal trap. You just don't know it yet. Because what, Cheryl? Didn't know what she hadn't bothered to check was that I wasn't some retired farmer with an old pickup and a dog. I was a land rights attorney for 32 years. I'd spent my life unraveling shady claims, fighting off crooked developers, and restoring land to the families who rightfully owned it. My office shelves were lined with court victories. My name had weighed in the county courthouse. I'd already taken steps before even stepping into hers. A month before this conversation, I'd pulled the full property history and confirmed my title at the county recorder's office. I'd also submitted an affidavit of possession and flagged the title with a formal challenge to any future claim. What they did wasn't just arrogant, it was illegal. Every dollar they'd invested into construction, every inch of pavement poured, every contract signed, it all sat on land that wasn't theirs to touch. And Cheryl, with her clipboard and pearls, had just confessed to the whole thing on camera, no less. See, I'd brought a body cam. Standard procedure. Legal in my state. And when she said we assumed it was abandoned, she'd practically admitted liability. She told me to back off. She hinted at intimidation. And when she said, you people, well, let's just say that's going to play real well in front of a judge and jury. By the time I left that office, I wasn't angry anymore. I was focused. I drove straight to my legal partner, a bulldog named Whitaker, who'd been waiting for my signal. He filed the first motion the next morning, temporary injunction, trespassing, property seizure. We demanded a halt to all construction and damages for unlawful use. The court moved fast. By Friday, all 120 units had red tape across them. Contractors were pulled. Investors panicked. And Cheryl. She suddenly found herself very, very interested in a settlement. But here's the part you don't know yet. The developer they partnered with, turns out they knew the land wasn't theirs before they started building. I found internal emails buried in a discovery request that show one of their junior analysts had flagged the parcel as active private over a year ago. They went ahead anyway, betting that I'd either die, give up, or never notice. That's not a mistake. That's fraud. That's racketeering. That, my friend, means we're no longer talking about a civil case. We're talking criminal. Which leads me to the real twist, the one that hit me just last week. The county board member who signed off on the development. Turns out he owns stock in the construction company. Quietly, indirectly, hidden behind a shell company tied to Cheryl's cousin. And now that I've filed for a subpoena on financial records, let's just say next week's going to get real interesting, because Cheryl may have smiled at me like I was nobody, but she just declared war on the wrong man. You see, when they looked at me, they saw a gray-haired old man with a dusty plot of land and a bad attitude, someone they could ignore, bulldoze or gaslight into silence. But what they didn't see was the truth. I'm a retired real estate attorney, 30 years deep in boundary disputes, quiet title actions, adverse possession cases, and fraud litigation. I've seen developers forge signatures, watched HOAs muscle families off generational land, and stood toe-to-toe with corporate lawyers who thought paperwork and money were all that mattered. So before I ever walked into that HOA office, before I said a word to Cheryl or any of those smug suits, I made sure every move I made was airtight. I pulled the original deed, scanned and archived by my family since 1957, and got it reconfirmed in person at the county assessor's office, complete with notarized certification. I hired a state-licensed surveyor, one I've worked, within dozens of trials, to restake every single corner of my land using GPS verification, permanent steel markers, and drone imaging. I filed an affidavit of ownership with the Land Commission, flagging the property as active, privately, held and not for development. And most importantly, I placed a targeted easement restriction on the lower southeast quadrant of the property, which, legally speaking, meant that any construction on or near that area could be halted immediately without notice, under penalty of civil forfeiture. And what did they have? No clean title, no proper permitting, no title insurance covering my parcel, no authorization to build, dig, or even enter my land. Their entire subdivision to 120 shiny new homes, all pre-sold, all funded by out-of-state investors, was built on a foundation of legal quicksand. And I had everything. Surveyor logs with timestamps and satellite overlays, time-stamped photos of their trucks trespassing, receipts of taxes paid, paper trail thicker than a Bible, and signed by half the county. So I filed my lawsuit. Not just one, multiple. I filed for injunctive relief, quiet title damages, construction halt, and civil trespass. I sent cease and desist letters to every contractor listed on their permit roster. I contacted the banks funding the development and formally informed them of an active title dispute, which made them instantly freeze further disbursements. I also reached out to the homeowners, many of whom had already signed contracts, and wired deposits and let them know they were buying homes on stolen ground. Panic spread like wildfire. Sales collapsed. Contractors walked off the job. But I wasn't done. I went after their legal weak spot insurance. You see, without a clear title, title insurance is void. And without title insurance, none of. The banks will approve mortgages, which meant their funding collapsed. Their lenders vanished. Their homeowners started demanding refunds, and that HOA they called an emergency board meeting. Cheryl finally called me after weeks of silence, smugness, and defiance, and asked if we could talk this out like neighbors. I told her no. I told her we passed neighborly a long time ago, right around the time they put rebar into my soil and told me to move on. I told her to prepare for court. I told her I had no interest in settlement, only in setting an example. Because here's what they didn't count on. This wasn't about money for me. This was personal. This was about dignity, about justice, about making sure no one else gets steamrolled because they're older, quieter, or less connected. Just when they thought it couldn't get worse, it did. One of the contractors they stiffed came forward. Turns out he had audio recordings of Cheryl telling him to just ignore the old man's fences. It's all ours now anyway. That recording, it's admissible, and it proves intent. Not just trespassing, not just negligence. Fraud. Now we're talking punitive damages. We're talking criminal referrals. And as of last week, the State Bar is opening an ethics investigation into the HOA's in-house counsel because it seems they may have knowingly suppressed material information about the land title. But the real kicker? The county permitting office, the same one that fast-tracked their development approval, just got slapped with a federal subpoena. Because there's evidence someone inside altered GIS records in 2004 to erase certain private parcels that just happened to be adjacent to high-value development zones, my parcel included. And guess whose name is showing up in campaign donation logs from that time? Cheryl's husband. So now it's not just a land case, it's a corruption case. And I've got the press calling, investigators digging, state officials sweating, and Cheryl. She hasn't been seen at the HOA office in 2 weeks. Word is, she's on leave. Out. Word is, she's lawyering up. And me, I'm just getting started. Because I just uncovered something buried deep in the original county plat. Something so damaging. So final that if I drop it in court, this whole development goes down in flames. Want to know what it is? Let's just say, the land Cheryl built her own house on might not be hers either. When my attorney served the cease and desist, the HOA board didn't just ignore it, they mocked it. It's Cheryl smug as ever. And so far as to print a blurb in the Fairgrove Lakes newsletter, calling me a disgruntled squatter who's trying to shake down the community for attention and money. Right. She even included a stock photo of a man in a tinfoil hat. That was the moment I knew they thought I was weak, that I was old, that I was bluffing, that I wouldn't follow through. But that also told me something else. They were afraid, because no one mocks what they're not worried about. So I filed the lawsuit. Full tilt federal court. Civil claims for trespass, unlawful encroachment, willful land theft, constructive fraud, and illegal development without consent. I didn't just ask for compensation. I asked for removal of everything. I demanded the demolition of every single one of those homes built on my land, plus damages for 5 years of loss of use, legal fees, and punitive damages for reckless disregard of property law. Their lawyers called mine, practically stammering, offering a sit-down conversation. My lawyer hung up. Then came the hearing. And when the judge read the case file and reviewed the evidence, the old surveys, the satellite overlays, the easement filings. The audio recording of Cheryl instructing contractors to ignore the boundary lines. He leaned back in his chair, took off his glasses, and said, slowly, the HOA has, without question, developed residential units on property. It does not own, has no right to access, and was explicitly warned about. The court orders a full halt to all development and considers the plaintiff's motion for demolition viable. The courtroom went dead silent. The HOA's lead counsel stood there like he'd just swallowed a brick. Cheryl wasn't even present. She'd skipped the hearing, probably thinking this would be dismissed like a nuisance claim. But the moment that ruling hit the HOA office, reality hit them back hard. Buyers started pulling out the same day. Word spread fast. Nobody wanted to be part of a development sitting on contested land with an active demolition order. Contractors walked off site. Banks froze the project accounts. Insurance adjusters backed away. Panic spread like a virus. Then 48 hours, received a private email from the board's interim president, offering a quiet settlement, undisclosed terms, confidentiality agreement, and a mutual understanding. I declined. Then Cheryl finally called me, voice trembling, half defiant, half desperate, and asked what I really wanted. I told her 3 things. First, every home built on my land would be auctioned by me. I would retain legal title, control the sale, and set the prices. Second, Cheryl would draft and sign a written, notarized public apology, admitting to misconduct, negligence, and malicious disregard of property ownership, to be printed in the same newsletter where she mocked me. And third, they would pay me $2.4 million in damages in full, non-negotiable. That number wasn't random, included projected rental income over 5 years, legal costs, surveyor fees, loss of timber rights, and interest. Their lawyer called me back 2 days later. No negotiations. They agreed. They had no choice. But here's the kicker, the twist no one saw coming. When the final title audit was done to confirm ownership boundaries before the court-authorized auction, my attorney found something buried deep in a supplemental plat filed in 1978, something even I didn't know about. A sliver of land just 0.6 acres, officially designated as Preservation Buffer Zone, recorded in my grandfather's name. Guess whose home was accidentally built right in the center of that tiny sliver? Cheryl's her $1 million dream home, the one she had bragged about designing herself. The one with the fancy stone chimney and wraparound porch, was sitting directly on top of a protected buffer her own HOA bylaws prohibit building on, which means it wasn't just mine, it was illegally constructed. And now that I owned the auction rights to the rest of the land, that her house was under my jurisdiction. And there's a clause in the HOA charter that states, any structure found in violation of preservation zoning must be removed at the owner's expense within 90 days of notification, or be subject to auction by the controlling title holder. I was the title holder. I was the controller. And I did serve her notice. So now the same woman who tried to steal my land with a smile has 74 days to vacate a tour, buy it from me at market price, plus damages. Think she can swallow her pride that deep? We'll see in part 5. 6 months later, I stood exactly where Cheryl once held court, same podium, same patch of manicured lawn, but everything had changed. The banners with her face were gone. Self-congratulatory signs boasting about Fairgrove Lakes, a modern community, had been torn down and replaced by something far simpler, far stronger. A clean metal plaque that read Cooper's Crossing Private Land, not an HOA. I stood up there with the microphone, looking out at the crowd, not bankers or developers, but veterans in worn jackets, retired firefighters with service medals pinned to their shirts, and widowed police spouses holding keys to homes they never dreamed they'd live in, let alone for free. That's right, I kept the homes, every last one of them. After the court granted me auction rights, I could have sold them off to the highest bidder, cashed out for millions more. But I didn't. I turned them into long-term rentals for men and women who actually earned this. Countries respect the kind of people Cheryl and her HOA types would never let pass the gates. The first year, rent-free, utilities covered, property, taxes paid in full. I wanted them to feel what Cheryl never gave anyone belonging. The look on her face when she saw that, worth more than any payout. She didn't even last 3 months after the judgment. The moment the public apology letter hit mailboxes and social media, her reputation crumbled. Her executive leadership career ended overnight. She resigned in disgrace, fled the neighborhood, and tried to delete every trace of her involvement. Online, but screenshots live forever. It didn't stop with her. Residents who had been sold on upscale HOA living realized their property values had tanked because of illegal development, fraudulent claims, and HOA mismanagement. Dozens of them banded together and filed their own class action lawsuit. Against me, but against the HOA board for negligence and financial loss. Several board members tried to claim ignorance, but the paper trail I submitted in discovery, including emails showing they knew the land was disputed and went ahead anyway, sealed their fate. By the end of the year, the HOA was gutted. No leadership, no funds, no authority, and me. I just quietly got to work. I hired local contractors, guys who'd been run out by HOA favoritism, to repave the roads, fix drainage issues the developers ignored, and build community gardens and benches where they once planned a private clubhouse. I added wheelchair ramps to every unit, installed veteran flagpoles on each lawn, and posted a single hand-painted wooden sign at the subdivision entrance that read, "This land was not taken. It was earned." People stopped calling it Fairgrove Lakes. They called it Cooper's Crossing. My grandfather would have liked that. But just when I thought it was over, another letter came. This time not from a lawyer, but from a federal auditor. Apparently, the HOA had received development grants under false pretense, citing full ownership of all buildable lots, which means fraud, which means federal charges. And guess who signed those grant applications? Cheryl. So while I stand here, watching a retired Marine and his wife move into what was supposed to be her forever home, Cheryl's preparing for something else entirely, a federal deposition. The system that tried to steamroll me is eating its own now, and I've got front row seats. But you want to hear something wild? One of the HOA board members who testified in my case, someone who once backed Cheryl, sent me a message last week, said he wanted to talk. Said he had information about how all this really started. Something about a backroom deal between the county, a developer, and someone on the zoning board. Something that could unravel a lot more than just one HOA. So maybe this wasn't just about stolen land after all. Maybe Cheryl was just a pawn in something much bigger. And maybe, just maybe, crossing is only the beginning. And that's how I turned their land grab into a legacy. Justice wasn't just served. It was built into every brick they laid on my property. If that story fired you up, hit that like button, subscribe for more real revenge stories, and drop a comment if you've ever dealt with an out-of-control HOA. Because next time, we dig even deeper.